This conference will now be recorded.
So I'd like to welcome everybody today to our webinar, the top 10 elder law questions and answers that everybody wants to know. Today's August 28th, 2020. It's 12:30 p.m. and we're going to get started. So this is my version of the David Letterman countdown. So we're going to start with the number 10 most frequently asked elder law question, which is that people ask, can they add a child's name onto their bank account and avoid a guardianship if they become incapacitated? Well, the answer is that if you add a child's name onto that bank account, yes, they'll have the authority to do whatever's needed with that account to pay your bills, to watch over that type of investment. But that will not give the adult child the ability to access any other assets you have, because we need a durable power of attorney to do that. So it's a much preferred, safer way to handle things by having a written durable power of attorney where you give permission to someone you trust to oversee and handle all types of financial matters if you are either temporarily or more permanently disabled or incapacitated. When we add our adult child's name onto an account as a joint owner, it has a totally different outcome. It means that we have made our child a joint owner. So in the eyes of the laws, if something were to happen to that child, for example, if the child were to get divorced, or the child has a business, but the business doesn't do well, so the child files for bankruptcy to get out from under the debt. In either of those scenarios, the child has to report the existence of this account on the court papers. And even though the child may not have contributed to the account, and you can prove that all those monies belong to you, legally the outcome is going to be that one half of that account belongs to the child. So potentially one half of the account is going to be subject to the divorce proceeding or the outcome in the bankruptcy proceeding, which would not be the result that any of us want. So the power of attorney for that reason is much safer, because it's not making the people we give the permission to a joint owner. We're actually giving them a responsibility, what we call a fiduciary responsibility. They're held to a high standard of care in overseeing and handling our financial matters, but it doesn't make them the owner of our assets. So the durable power of attorney allows us to give permission to deal not just with bank accounts, but it could be other kinds of assets such as real estate, maybe our home, maybe a rental property, whether it's in Florida or elsewhere in the country. It allows us to give the ability to sign a tax return and pay the taxes. We can give permission, if it were necessary, for our fiduciary to access any kind of retirement plans. Let's say we become incapacitated and we need to pay for home health care services. And maybe the accountant is recommending that the money be taken first from a retirement account because there could be a preferred tax treatment. Well, we need the durable power of attorney to give specific permission for that type of financial decision to be made. So we don't want to just look at things in a vacuum and think of just one account. We really want to think more broadly as to all the different types of assets we have and all the different kinds of financial decisions that we make day to day or week to week when we're healthy enough to do that. So that's the type of authority we want to give in the durable power of attorney document. The number 9 most frequently asked elder law question is, should I disinherit my child who has a disability or has special needs and give their inheritance to their sibling to hold for them? Now, I hope that with the advent of the internet and more information being available and more elder law attorneys becoming available, that people will not take this type of course of action. It's something that used to be done many years ago where a parent would turn to an adult child who was healthy and physically able to oversee the care of their sibling who had special needs, and they'd say, look, I'm giving everything to you, but my intention is that you're going to use half of it to take care of your brother or your sister. You're not going to spend it. The problem was that legally there was no way to enforce it when it was done in that manner. And again, God forbid that something unexpected, unintentional happened to the child who was given the entire inheritance. That money that was intended to be used for the child with a disability would have been lost. Again, let's use those examples we just talked about, which is a divorce could happen unexpectedly, a bankruptcy, there could be a car accident, and perhaps the child was sued above policy limits. So the unfortunate consequence would have been that the child with the special needs would have seen nothing. There would have been no inheritance to help them lead a better life, to have better quality of care. So the preferred way that I like to handle this type of situation is to have the parent create what is called a special needs trust and put the inheritance for the child who has the disability into the special needs trust. Now, we've been doing this for probably close to 30 years, and it's a great tool to use because we know that that money that's set aside is going to be used to improve the lifestyle and the care of the child with the disability. And by putting a trusted sibling or another trusted relative in charge, making them the trustee, we know that they're held to that fiduciary standard of care and that the money is not theirs. They're not the owner. So the money is going to be protected for the needs of the true beneficiary and not unintentionally lost. And you know, the great thing about a special needs trust, well, there are many great things, but one of them is that you get to paint the picture. It's as if we give you a blank canvas, a number of different colors of paint and different size paintbrushes, and you get to decide by how we write the trust how you would like to see those monies used. So for example, we might write that the monies can be used to allow the beneficiary to travel, to explore the world, to be able to attend family events, to be closer to family members that might be in another state. We can include language that talks about being able to use the money for therapies or treatment that are not yet approved in our country. That might be considered experimental, but you want your beneficiary to have every option, every opportunity possible to lead a better life. So you get to design how the special needs trust actually works, which is why I think this is a great tool. And when your beneficiary passes away, if there's any monies remaining in the special needs trust, your trust will state who is going to inherit what's left. So you could, for example, have the remaining assets go to your other children or other family members, or You might want to leave it to a charity that helps support people with the disability that your child has. So the monies are not going to go back to any of the government agencies that might have provided your child with assistance. So it's not going to go back to the Medicaid agency, and it's not going to go back to the Social Security Administration. The number 8 most frequently asked elder law question is, can I leave everything I own to my children from my first marriage and disinherit my current spouse? And you might be surprised, but I hear this question quite often when it's a subsequent marriage, subsequent to the first, could be a second or third marriage, or somebody who's even on their 8th marriage. And so what you need to understand is that the answer to this question depends on several factors. The first is that here in Florida, we protect the rights of a surviving spouse. So Florida says at a minimum, that surviving spouse must receive at least 30% of the assets that the deceased spouse owned. Now, this includes assets that were in the deceased spouse's name alone. It can include assets that perhaps the deceased spouse named somebody other than their spouse to inherit. They might have named somebody as a beneficiary. Believe it or not, all those assets are brought into the picture in order to calculate what the 30% valuation is that the surviving spouse is entitled to receive. So if a person was to not leave anything to their husband or wife in their will or even in their revocable trust, the outcome is going to be that that surviving spouse will receive 30%. And yes, you did hear me correctly, that this law cannot be bypassed simply by a person going to an attorney, having the attorney write a revocable trust to avoid probate, putting their assets into the name of the trust, thinking that their surviving spouse won't be able to reach the assets. That no longer happens. Again, Florida protects the rights of the surviving spouse. So the 30% will include assets in a revocable trust. So there are only 2 ways legally that this outcome could be avoided. The first is that the couple, before getting married, would need to go to an attorney, preferably a family law attorney, who would have them sign a prenuptial agreement. So a prenuptial agreement is where both intended spouses disclose to the other the existence of what each of them owns and any income that they each earn. If there is a valid prenuptial agreement that states they are waiving their right to inherit from the other spouse, then that takes over. The other option is if the couple did not have this discussion before getting married, they got married, and now they're realizing what Florida law says, they can, after the marriage, go to a family law attorney to get advice. Each spouse should be represented by their own separate attorney, so there's no perceived conflict of interest in using one attorney to represent both spouses. And in the postnuptial agreement, each of them can waive their rights to inherit. The number 7 most frequently asked elder law question is, will Medicare automatically pay for my stay in rehab after I leave the hospital? Now, this is a question that is most often asked by a person who is over age 65 and has become eligible to participate in the Medicare program Medicare being the primary health insurance program that would cover things including our hospitalization stays, physician visits, durable medical equipment, and prescriptive drugs. So the current rule, and this applies nationally because Medicare is a federal program, it is not state-based, is that if a person has a 3-day hospital stay, then during the first 20 days in a rehabilitation facility, Medicare will cover 100% of the cost. Now, here's something that's a really important fact for you to know, and this has come about in the last year. If somebody goes into the emergency room and they're evaluated in the emergency room and then discharged, but they are never actually admitted into the hospital, they will not satisfy that 3-day hospital stay. So Medicare will not cover anything. The other fact that you need to know to be an informed consumer is that if for any reason the patient goes from the hospital to their home first before going to the rehab facility, Medicare will also not pay. It's necessary that the patient, when being discharged, go directly from the hospital right to the rehabilitation facility. Around the 20th day in rehab, the facility is going to reassess the patient and the patient's needs. And this is important in order to determine, will Medicare provide partial coverage from days 21 through day 100? And traditionally, the reimbursement rate for that period of time is 80%. The remaining 20% is the financial responsibility of the rehab patient. Now, for that reason, some people, when they become eligible for Medicare, will obtain what is called a Medicare supplement. We also sometimes refer to it as a Medigap policy, meaning that that policy is intended to cover the gap between what Medicare will cover and what the full private pay cost of care is. And this is a standardized supplement program. There are basically 10 different kinds of supplements. They are lettered, not numbered, and the federal government oversees all insurance companies who choose to offer Medicare supplements so that the same type of services are covered under each plan, no matter whether a person buys a plan through United Healthcare or AARP or any other insurance company. The other thing to be aware of, and this is going to be addressed in one of my webinars in September, is that the standard when you're in a rehab has changed. It's no longer what used to be known as the improvement standard, but actually if the services, the therapy is necessary for the patient to stay at the level they've achieved and not deteriorate, go back to where they were when they were first admitted, that's also sufficient for Medicare to provide coverage. The number 6 most frequently asked elder law question this year is it okay that my last will and testament leaves everything I own to my 3 children, but I designated only one child as beneficiary on a large account? Now, if you're thinking to yourself, wow, is she talking about me? I've done that. Let's talk about the right way to do things. So the answer is no, it's not okay to do that because you're going to end up with different results than you probably intended. So let's start with the basics. And the first basic foundation of understanding estate planning is that what is written in the will can only control assets that are in your name that don't have a joint owner, because then when you die, it automatically goes to the joint owner, and that the asset does not designate a beneficiary, because if it does, then that financial institution is going to deliver the asset to the beneficiary that's on record, whether it be at the bank, whether it be at the investment company. If there's a joint owner, if there's a beneficiary, that asset will avoid the will. It will avoid probate. So the will is not going to control the ultimate outcome. So you have to be very careful here, because this is where the legal consequence may not always be the moral intended consequence. So you might intend that the child you designated as beneficiary on that one account is going to share the money with their other two siblings. But that is not legally enforceable by the other two children. So if we want to avoid family disharmony, if we want to avoid a family potentially being broken up and there being misunderstandings, then we don't want to put the name of one child as a joint owner or even as a beneficiary on that account. You want your will to control the ultimate disposition. So don't add anybody as a joint owner, don't add anybody as a beneficiary. If the concern is who's going to help me when I'm alive and I might get sick for a short time or I might be incapacitated, then that's a good reason for us to put a well-written, durable power of attorney into place. It won't in any way interfere with your estate plan. The number 5 most frequently asked elder law question is, what can I do if my father's second wife refuses to disclose her financial information to help him qualify for Medicaid? Now, while I chose a scenario of a father being ill and needing Medicaid, it can happen equally as many times for a wife. And we do tend to get this question mostly in marriages that are not a first marriage, where people have been married before, they bring different assets, different income to the subsequent marriage. Perhaps they even keep their assets separately, except for a joint account that they contribute to pay the joint household expenses. So it's not all that unusual to see this kind of scenario where when one spouse begins to decline or perhaps goes to the doctor and receives a diagnosis that is totally unexpected, sometimes the other spouse panics, and out of fear, they make ill thought out decisions. I've seen things such as the well spouse leave because they're afraid of the responsibility that's going to fall on them to take care of the spouse. I've seen spouses refuse to disclose their financial information, refuse to be helpful, to qualify their spouse for Medicaid, and it's very sad and very unfortunate. So that's all the more reason why it's important to correct any myths, any misunderstandings or misinformation that people are using to act upon. So when applying for Medicaid for one spouse, the government does require that the application disclose resources and income for both spouses, simply because they're married. However, what we want to first try to do is gain the cooperation and the understanding of the other spouse. And so we might want to invite that spouse to a meeting with the children of the spouse who's not healthy and try to allay any fears or concerns that they might have that they're going to have less to live on, or they themselves are not going to have their medical needs met. So we want to take care of understanding what the concerns and their fears are. That way we can actually provide the correct information, which is that the law, the federal law, as well as the state Medicaid law, wants to make sure that both spouses are taken care of. So there are certain standards to make sure that the spouse who stays in the community can pay for their household expenses and meet their own needs. They are allowed to have a certain amount of resources, meaning bank accounts, investments, stocks, and bonds, to meet their needs. If after that kind of discussion, the spouse is still not comfortable, does not want to share information, perhaps is not as cooperative as we had hoped, then what can be done on the Medicaid application is to request what the federal law calls spousal refusal. What this means is that the other spouse is refusing to disclose the information and is refusing to use their resources for the support of their ill spouse. Now, there are two forms that will have to be completed and filed along with the Medicaid application at that time. One document needs to be signed by the spouse applying for the Medicaid. If that person is not capable of signing the form, either for physical reasons or perhaps they're not cognitively able to understand it, then we need to find out if there is somebody who holds a durable power of attorney that would have permission to sign it on their behalf. The second document needs to be signed by the other spouse. So it will say that they are married to the person who is applying for Medicaid, and they are refusing to disclose their resources and they're refusing to share the resources for the support of the spouse. Once those two documents are filed with the Medicaid application, what happens here in Florida is that those documents are sent to the legal department to review, and the caseworker is instructed to review and process the application as if the person applying is a single unmarried individual, meaning as long as their resources and their income meet the requirements, which is no more than $2,000 in resources and limited income, the caseworker will approve the Medicaid application. Now, we don't know if this process might change in the future. In certain states like New York and California, what happens is that the Medicaid legal department will send a letter out to the spouse asking them to pay for a certain period of time. If the spouse ignores the letter or refuses to in any way negotiate, what those states have done in the past is they have filed a lawsuit against the spouse, but ultimately those lawsuits have resolved, they have settled, they do not go to trial or to a jury, and the spouse pays a small amount, pennies on the dollar, of what has been incurred up to that point, and then Medicaid is willing to continue to pay going forward. So spousal refusal is available if we cannot get that other spouse on board, but our preference is really to first meet with that spouse and address any misunderstandings they may have about how the law protects them and what they can keep. The number 4 most frequently asked elder law question is, What will happen to my mother's Medicaid benefits when her home is sold or if she receives a settlement from a lawsuit? And this is a very common concern that families have. So again, let's start with the basics. We are very lucky here in Florida that we have certain protections under our law that also extend when people apply for Medicaid. And what I'm talking about is that here in Florida, we have what is called homestead and homestead protection. Most people tend to think about homestead protection in that they get a reduced evaluation and assessment on their homestead when having to pay their real estate taxes in the fall. Well, it's actually a much broader protection than that. It also means that while the owner is alive, nobody can file a lien on the house. The only exceptions to that law is if you don't pay your mortgage, the mortgage lender can foreclose on the home, or if you had work done on your house. Let's say you had a pool installed or you had a deck installed and you did not finish paying the contractor can file what is called a mechanics lien to get you to pay their invoice. But for any other kinds of debts, such as a credit card debt, the home in Florida is a protected asset. And that protection continues even when somebody qualifies for Medicaid assistance. Here in Florida, we will not count the value of the home should somebody need Medicaid assistance. And that's true even if the person is no longer able to stay in their home. Let's say the person needs care in an assisted living facility or a memory care center, or perhaps they need the highest level of medical care that could only be provided in a skilled nursing care facility. They do not lose that homestead protection. The home will not count. They will not lose their Medicaid assistance. But we always need to look at what the law gives us and ask ourselves practically, does it make sense to keep the home? So the reason we have to ask this question is because if the owner who is receiving Medicaid assistance is not living in the home, they must contribute their income, which might be their Social Security, retirement, perhaps a pension. It might even include a distribution from a retirement account. All those sources of income have to be contributed to the facility and applied toward the cost of their care. They're not going to be able to keep that money and use it to pay for the real estate taxes, the homeowner's insurance, or the utilities. So that's why I say, from a practical point of view, the family needs to evaluate, are they in a position financially to pay for those ongoing expenses? If they are, then it makes sense to keep the home. But if they're not able to practically take care of those financial expenses, then you might need to explore either renting the home to cover those costs, or if the family does not want to be a landlord, then they may need to consider selling the home. So that's when this question arises. It's, will mom lose her Medicaid assistance when the home is no longer a home, but now it's the cash proceeds? And once it becomes cash, it no longer receives that homestead protection under the Medicaid rules. So when a person accepts Medicaid assistance and they sign their application, they have to agree to notify the Medicaid agency within 10 days whenever there's a change in financial circumstance. So the sale of the home would be a change in financial circumstance that needs to be reported. So how do we then protect the proceeds and prevent a loss or a gap in Medicaid coverage? Well, ideally, we want to have as much lead time as possible to explore the different options. We might consider a special needs trust if the Medicaid recipient is under age 65, because the federal law limits being able to use that kind of special needs trust for people under age 65. If we have somebody over age 65, another planning option is a pool trust, which is a type of special needs trust that we can use for older individuals as well as younger individuals. We might also want to explore what is called a personal care agreement, where the parent agrees to compensate a family member who is helping to care for that older adult, who is actually providing services to them. So it's essentially an employment contract where the parent is receiving, or the elder is receiving, services that have a value to them, and they in turn are compensating the caregiver at a fair market value. So those are just a few options that are available when somebody who's receiving Medicaid either sells their home, or perhaps if they're injured and filed a lawsuit and the lawsuit settles, they're now receiving the lawsuit proceeds. So we can use these as options to protect the proceeds as well. The third most frequently asked question is raised when people move to Florida from another state, from somewhere else in the country, and they perhaps come to Florida already having some legal documents that were prepared by an attorney in the other state. So they're wondering, do I need to change my legal documents every time I change my domicile? And the answer to this question is you don't necessarily need to have your documents rewritten. Florida will honor legal documents, and what I mean is a last will and testament, a revocable trust, a durable financial power of attorney, or a healthcare power of attorney that were prepared in another state, so long as the document met that other state's requirements for proper execution. So this will mean that it had to have been signed in the proper locations by the individual, that it contains the proper number of witness signatures, and certainly not least important, if that law required the document to be notarized by a notary public, it must be notarized. So if those requirements are met, then you do not necessarily need to have your documents rewritten when you move to Florida. One thing to keep in mind is that certain states, they tend to be in the Northeast, such as New York, have slightly different requirements as to the execution of a last will and testament. For example, here in Florida, a last will and testament is required to have at the end of the document what we call a self-proving affidavit. And this affidavit is signed by the person making the will, the two witnesses, as well as the notary. So all are in each other's presence. They see each other signing, and everybody's signature is on this affidavit. Without this affidavit, it becomes a much more difficult process to admit a will to the probate court, to be able to probate the assets. New York, for example, does not require this self-proving affidavit. So when a former New York resident relocates to Florida, it is a good idea to do a new will that will have the self-proof affidavit. If the individual chooses not to make a new will, there are more steps that are going to have to be followed in order to have that will admitted to probate. We actually have to track down and find one of the witnesses to the will, and they have to go to a courthouse near them to sign an affidavit. So it's really recommended to avoid all those additional steps that would need to be taken after the person dies, and just simply make a new will when you move to Florida. The second most frequently asked elder law question this year has been, can I qualify for veteran aid and attendance benefits if I transferred assets? Now, this has been a popular question for many years for the reason that the Veteran Administration rules for the aid and attendance program have not been a mirror image of the Medicaid rules. And for that reason, people can choose to qualify for the aid and attendance program because it was different and sometimes simpler than to qualify for Medicaid. However, at the end of the 2018 year, Congress finally passed a bill that had been pending for several years to start to make the Veteran Administration rules more aligned with the Medicaid qualification rules. So whereas Medicaid has a 5-year look back, which means when a person signs their Medicaid application, they will be asked, have you given away any assets of value within the 5 years prior to applying for Medicaid? And the result is that you must honestly answer the question and report when you transferred assets and the value of those assets. Now, the result of the transfers is that it will cause a delay in qualifying for Medicaid. So the Medicaid application will be denied. The person will have to find another way to pay for their long-term care needs until what is called the penalty period has been served and expires. Now, under the new VA rules for the aid and attendance program, there is a 3-year look back. So if there was a transfer of resources within the 3-year period, they have to be reported on the application, and they will delay that individual being approved for the aid and attendance program. If the transfer was beyond more than 3 years ago, then that transfer does not need to be reported. The net worth currently for a person to qualify for aid and attendance is approximately $129,000. So if somebody had, let's say, $150,000 and they gave away money to bring them just below the $129,000 threshold, they are going to be delayed qualifying. But if they were already under the net worth limit of $129,000 and they made a gift, they made a transfer, they will not be penalized because they were already eligible. They were already within the net worth requirement. And I am going to suggest, if that's a topic of interest, for you to join me in September. We are hosting a webinar where we're going to explore in greater detail what the eligibility requirements are for the aid and attendance program and how to qualify. Now, we finally get to the number one most frequently asked elder law question. Will I lose my house if I or my spouse applies for Medicaid? And this question is a concern not only when the person applies, but equally what will happen when the Medicaid recipient dies? Will the Medicaid agency step in and take the home? So if you remember a few minutes ago, we talked about how Florida provides this great protection here for the home. And the home remains a protected resource even when the owner passes away. The key is that the home must go to either a surviving spouse, children, or other family members that under the law would be considered an heir. If, however, the Medicaid recipient chooses to leave their home to somebody that is not a spouse, not a child, not an heir, maybe their best friend, maybe their lifetime partner that they never legally married, then in that situation, Florida's protection will not protect the home. And at that point, the Medicaid lien will attach and will look to recover up to the amount of Medicaid assistance that was paid out for that individual's care during their lifetime. So whether you leave your home to a family member in a last will and testament, or whether you leave it to a family member in a revocable trust, either of those ways will protect the home should you need Medicaid assistance in the future. But if you choose to leave the home to somebody else that's not related, or even to a charity, it's doing a wonderful good deed, but unfortunately the Medicaid lien will attach. So do keep that in mind. So at this time, I'd like to invite everybody to unmute their microphone and feel free to ask a question, or you're welcome to use the chat box and type your question.
Stephanie, I have a question. Good afternoon. You mentioned that one's home is not attached to a Medicaid lien if it's left to a spouse, offspring, or an heir. Could an heir be considered someone's brother or sister?
That's a great question, Lisa. Thank you for asking it. Yes. So it could be a sibling, it could be parents or grandparents that are still alive, it could be a cousin, and it doesn't have to be a nearby relative on the bloodline. It could be somebody who's far removed.
Okay. Thank you. Good question. And then, I'm sorry, does anyone have another question? You talked about if someone is receiving Medicaid benefits, but the Medicaid recipient, and say for instance, his or her daughter or son decides to be the person that will be providing those services, right? That they would be possibly reimbursed via fair market value for those services. I'm assuming they would have to have an assessment indicating what the needs are, and how does that work?
So that's another great question that you're asking. So what we want the caregiver to do is keep a time log of what they do on a regular recurring basis, whether it's daily, weekly, once a month. And there could be different types of services being provided. For example, the caregiver might be making doctor appointments and providing transportation and overseeing medical care and medical services. It might be that they're living with the elder, or the elder is living with them, and so they are preparing meals, they're providing laundry and linen services. It might be that they are handling the finances and they're reviewing the mail and they're doing bill paying. They're communicating with the accountant during the year. It can also be that they're taking care of the home. They're taking care of other property that the person owns, a car or a rental property. So those are the types of services in a very broad way that Medicaid considers to be compensable, as long as the service is actually being provided and they're spending a reasonable amount of time to provide the service. Would anybody else like to ask a question about any of the top 10 elder law questions? Well, I'd like to thank everybody who joined me for today and remind you to go to the website www.fl-elderlaw.com to our events and calendar page where you'll see all the upcoming webinars. Our next webinar will be held on September 11th, and I'm going to be discussing how everybody can be an effective advocate when you are advocating for somebody that is a nursing home resident. And if you happen to miss a webinar, don't worry, we record them and they're uploaded through YouTube to the website. So you can go to our recordings page and see any of the recorded webinars. And don't forget that also on the website is a free document checklist to help everybody plan for their estate planning needs. And you can also download a gift certificate for a discount on a consultation. So again, I want to thank everybody who joined me today. Have a great weekend. Remember to practice self-care during this challenging time and stay healthy.